all awake for the last hour and a half. What we're going to do, the format of this last panel is I will introduce the speakers, I'll give a 3-minute scene setter, and then we're going to do a crossfire discussion of questions related to the genocide issue. Within that, Maria is going to do a PowerPoint presentation. We'll get back into the crossfire discussion, and then we're going to open it up to audience questions and answers. We may end up at 5 o'clock, but if you guys are really invigorated with lots of questions, we'll keep going. So to begin with the intro of the speakers, you've had a long introduction of Stephen Rapp. He's still Stephen Rapp. Bill Schabas has already been introduced, as has Maria Szonert. Who hasn't been introduced yet is my friend and colleague David Crane behind me. David Crane has had a long and illustrious history, starting out as a JAG and working his way up as a lawyer through the military ranks. He was Inspector General of the Department of Defense. He was Assistant General Counsel of the Defense Intelligence Agency. He was Dean of the U.S. JAG School when I met him. He was Chief Prosecutor of the Special Court for Sierra Leone, the first American to hold a Chief Prosecutor position of an international tribunal since Robert Jackson. He is now a professor at Syracuse Law School, but most importantly for his friends at Case Western, he teaches every year at our Summer Abroad program, teaches a class called Atrocity Law and Policy. And a few years ago, he got an honorary degree from our university. So this is his first time up. Why don't you join me in welcoming David. So the scene setter for this panel on whether Katyn was genocide, I think it's useful to tell you a little bit about the history of the Genocide Convention, very briefly. It was about 62 years and 2 months ago that the UN adopted the Genocide Convention, and today it has 140 parties. After decades of dormancy and pretty much irrelevance, the Genocide Convention has become an important legal tool in the international effort to end impunity for the worst crimes known to humankind. Both the term genocide and the convention were the byproducts of the atrocities of Nazi Germany that we've been describing today. Winston Churchill called Hitler's final solution, quote, the crime without a name. And Professor Raphael Lemkin, who I found out recently was a professor for a while at Duke University, my alma mater, he coined the term genocide by combining the Greek word genos, race, with the Latin word side, or side, for killing. The new word was not included in the Nuremberg Tribunal's charter. It was not one of the crimes that Nuremberg had jurisdiction over. However, it was included in the indictments. And in his closing argument, the French prosecutor stated, quote, this is a crime so monstrous, so undreamt of in history, that the term genocide had to be coined to define it. When the UN General Assembly adopted the Nuremberg Principles in 1946, it specifically declared genocide to be an international crime, and it directed that a treaty aimed at its prevention and punishment be negotiated. The negotiating history of the Genocide Convention has been a subject of Bill Schabas's books. One of the important things about it for our purposes is that during the negotiation, the Soviet Union insisted on the exclusion of political groups from the definition of genocide, which is giving, for example, the Cambodia Tribunal fits in trying to prosecute the crime for the old Pol Pot Khmer Rouge regime, and it might make it difficult in the context that we're going to be discussing. The convention defines genocide as a series of enumerated acts committed with the intent to destroy in whole or in part a national, ethnical, racial, or religious group as such. It renders genocide a crime under international law. It requires state parties to undertake to prevent genocide, to punish those accused of perpetrating such acts, and it confirms that official position is not a defense. With that introduction, let's begin our crossfire with the first question, and that is, panelists, why is labeling the Katyn genocide, or the Katyn incident genocide, I'm putting the cart before the horse, why is labeling Katyn a genocide seen as so important? And related to that, I wonder if you'll comment on whether there are parallels to the debate about whether the Armenian massacres should be called genocide. care to weigh in?
Sure. I thought about this issue, of course, of the Armenians. I think the Poles have a big advantage over the Armenians, is that at least now the Russians have admitted it, which the Turks haven't done yet. As for the issue of the legal interest and the significance of labeling it genocide, aside from the sort of the symbolism of it, which is very important to people, there are legal consequences, and I think that underpins it all. In the debate between the Turks and the Armenians, everybody's thinking about their legal positions, and there are some interesting legal consequences. The first one is whether the Genocide Convention could apply to events in 1940, or whether it could apply to events in 1915. The convention is silent on the question of its temporal application. It was adopted in 1948. There's a rule of interpretation in the Vienna Convention on the Law of Treaties that says that treaties are deemed to be prospective unless the content or the context suggests otherwise. But there are lots of interesting arguments to suggest otherwise. And that could mean, aside again from the other question of whether or not you can actually get it to stick in terms of the facts, that what happened at Katyn in 1940 would be a genocide within the meaning of the convention, within the narrow definition of the convention. If the convention itself can be deemed to apply to events in 1940, that means that Poland could take Russia to the International Court of Justice under the Genocide Convention for example, failure to investigate and for responsibility for the crime. So it's not without interest, certainly. And the other thing about the Genocide Convention, as opposed to the other categories of crimes which we can use to categorize Katyn, is that the convention does leave the door open to the International Court of Justice, to the World Court. These are not for individual prosecutions. This is for state-to-state litigation. So it's an interesting argument. There are strong views on both sides. The International Court of Justice, in one opinion in the case between Bosnia and Serbia in 1996, referred to the absence of a temporal provision in the Genocide Convention, and it reiterated this in 2008 in the case of Croatia versus Serbia, but without any more detail. It just said the convention doesn't say anything limiting the temporal scope, but whether that would mean we could go back before 1948 is an interesting question. It's, by the way, a good argument to use in negotiating a settlement, too.
Stephen, let me ask a wrinkle on this, and then we'll get to you as well, David and Maria. When I was at the State Department in the Office of the Legal Advisor during the Bosnia, what we now call genocide, there were big debates about whether it should be labeled genocide. And then when Rwanda took place, again, the United States didn't want to call it a genocide. And then when Darfur took place, the whole world is debating whether it's genocide or not. Why is it the label so politically powerful? And what are the political implications for calling an incident genocide and calling Katyn genocide?
Well, I mean, first of all, keep in mind that the name of the convention is the Convention for the Punishment and Prevention of Genocide. And if you look at the provisions, there is a requirement that the state parties act to prevent a genocide. And so the question that when you have these situations is in Yugoslavia or Rwanda, if you find it a genocide, then the question is, what are you doing to stop it? And the sort of ideas require, putting boots on the ground, taking very difficult decisions. And so because of that, there's this tendency on the part of some to try to say, well, it's not quite there, or we can't say. It was frankly a little easier to make those kinds of comments back before these international tribunals got into business, and the Rwanda court, we indicted 90 people for genocide, and practically everybody who's been convicted so far has been convicted of that crime, and famously in the Yugoslavia tribunal, genocide attempted in many cases as a charge, but established only in regard to Srebrenica, that the murder of 8,000 Muslim men and boys by Bosnian Serb forces was the crime of genocide, one individual and was found convicted of complicity in it several years ago, and just a few months ago, several other individuals explicitly of genocide for that. So it does have, now we know more clearly what a genocide looks like. On the other hand, there's still some ambiguities in it. We'll talk about those in a little bit, but I do want to emphasize that from a symbolic point of view, this is a very powerful thing, and many groups that have had horrendous victimization, thousands, tens of thousands, hundreds of thousands, even millions of victims, immediately say this is an extremely grave mass atrocity. It's therefore a genocide. If you go to Phnom Penh and you discussed the Cambodian court and dealing with the genocide issue and the challenge for the prosecutors, you'll find that this center where 15,000 people were tortured into making confessions of essentially of treason is called the Genocide Museum. But of course, the crime, and to a large extent, though there were targeted Muslims because they were particularly unwilling to submit to control by this communist state, was political. They destroyed people because of their pursuit of this utopian ideology, this desire to take the country back to year one. So it doesn't look like the mass crime was a genocidal crime. If you go to Bangladesh, as I was there 3 weeks ago, and I've never been, it was a very intense four-day period. I was staked out by 50 reporters everywhere I went to ask about my views on how to prosecute the Bangladesh genocide. But of course, this was a crime that largely involved, at this point, Bangladeshis killing Bangladeshis. Because of a perception that particular individuals were supporting national independence. And so everywhere you go, you find people saying, it's got to be genocide, because somehow it doesn't matter if it's not. Well, the one point I want to make, and we can get into the Katyn question, because I think it's a really important one from a legal standpoint. But from a moral standpoint, if you murder 2 million or 3 million people as part of a widespread and systematic attack on political grounds or whatever the grounds are as part of that widespread and systematic attack, if it's a part of a plan or policy, that is a crime against humanity of enormous proportion, as grave or graver than someplace else where far fewer have been killed in a genocide. And so I think we've always got to be careful not to say, well, genocide is always the most grave, because sometimes the numbers of victims and the heinous nature of the offenses, et cetera, constitute other crimes. And given the circumstances, they're as grave, but because of the legal definitions that we have in the Genocide Convention, we can't call it that.
And David, what's your take?
Well, I think Steve brings up a very good point here, particularly dealing with the politics of all of this. And I've written about this called semantic indifference. What does it matter? 2 million by genocide, 2 million by a crime against humanity, whatever it's called. It's still an atrocity which needs to be dealt with. And it's interesting, are we developing, I just asked this rhetorically, are we developing a tier system related to our international crimes? Genocide seems to ring a little bit more harsh than, let's say, a war crime or a crime against humanity. And from a diplomatic and a political point of view, there's always legal ramifications if you invoke the G word because of obligations. And also just the way the public reacts to it. If we called it the Katyn atrocity or the Katyn event, does that cause people to step over it? It's an issue. So if we call it the Katyn massacre or the Katyn genocide, or call it a genocide, people tend to perk their ears up a little bit more. And the only reason I'm making this point is that we have to be very cautious about, in the real world, of how people react to an event, that we're careful as to how we describe it. Because if we describe it wrongly in this 24-hour news cycle, something that needs to be addressed may just be pushed aside and the next news cycle happens.
And Maria, in your context, why is it so important at the end of the day that Katyn be labeled a genocide?
Well, from the Polish standpoint, if I may, Poland has been partitioned 4 times within the past 200 years, since the 18th century. 3 times by Russia, Prussia, and Austria, and the Ribbentrop-Molotov Pact is being considered as the 4th partition of Poland. So Poland has been denied the right to live and the right to exist at least 4 times in the recent history by her 2 powerful neighbors. And I think Poland today doesn't have the atomic weapon to defend itself, but Poland can't defend itself for the future on the moral ground. That moral ground is that weight that the word genocide carries with it. Because Poland was subjected to genocide, and not once. And we are entitled to that moral defense to protect our future as a country.
With that as an introduction, Maria, why don't you come up and start your PowerPoint presentation and show us, this is the case of Maria the prosecutor for why Katyn should be considered genocide, and then our panel, I'm sure, will critique it.
We were blocking the...
With such a distinguished panel. I don't know, let's see. F5, yeah, no? Okay, I think I'm getting
Tim will be
this.
here in a second if you don't.
If I don't manage that. I think I'm getting there.
There we go.
Okay, and I need to switch to the presentation mode, and I don't even have my, okay, very good.
And then just push down. All right.
Okay, well, thank you for listening. So this is the traditional definition of genocide, original language from the 1948 definition that was subsequently adopted by the Statute of Rome of 2002. And my argument will be based on this classic definition. The elements of the crime to the Statute of Rome with respect to the killings, because we have 5 different types of acts that constitute genocide. One of them is killings, and I will be focusing primarily on the killings, but of course I will be referring to other acts that also constitute genocide, which are relevant. So those are we need to establish that people, perpetrator killed, and that was a protected group, and I will limit my approach to 3 protected groups, which is national, ethnic, and religious. And we need to meet the high standard to prove that the perpetrators killed members of the protected group with the intent to destroy that group, specific intent. And we need to look at the evidence of that specific intent in the context of facts and circumstances, and also in the manifest pattern of similar contact now, before, and after. So I don't want to spend much time on the fact of killing, because that has been proven, and I assume that this is the easy component of the crime that the Katyn crime meets. Now, the issue of the question is whether the people killed pursuant to the March 5th, 1940 execution order, which was drafted by Beria, approved by Stalin, and adopted by the Politburo, whether that document represents a proof that those people intended to kill the Polish national group. And I'm quoting here the language from that specific order. I took the liberty to put in bold the quotes from the March 5th order, and the original full text is in your text, because I apologize for taking this out of the context, but we do have it in the conference material, the full order, because we need to understand it in its entirety. But this is critically important. With respect to the officers, 14,736, they were specifically spelled out in that order that more than 97% Polish by nationality. Straightforward. now, even we have proof that before determining this 97%, Beria requested a report on the nationality of the Polish prisoners of war. And based on that report, he came to that conclusion and he put it into that death order. Now, the second group, those are regarding the prisoners of war. The second group of 7,300 civilians that were sentenced to death by the same document. What this order is saying that currently in the prisons we have 18,632 people, okay? And out of this number, we know that 10,685 are Poles, okay? So below the last quote, I ordered to execute 11,000 of them. There is a correlation between the 10,685 and 11. Whether this is a correlation that the court would admit or not, I don't know, but I'm submitting that as evidence. Now, the case law, I was trying to do my best to research the national group. I think most of the modern cases relate to the ethnic groups as opposed to national groups. But there is some, I found some relevant language. And what's critically important in my opinion is that there is a prevailing view that the way the court looks at the definition of the national group is not whether it really was purely a Polish national group, but how the perpetrator perceived that group in the moment of killing it. So in other words, it's not the objective component, but a subjective component. So I would argue that if they put 97% Poles by nationality, that meets the standard of national group, which is the protected group under the Genocide Convention. So we, in that sense, we meet the requirement, the element of the crime that this was directed at the Polish national group, which is the protected group under the under the Genocide Convention and the Statute of Rome. Of course, we can argue about the scope. In other words, whether to kill 25,000 Polish officers was enough to destroy the Polish national group. I already talked about the fact that this was only one of the components because we had a huge deportation policy going at the same time, impacting hundreds of thousands of Polish nationals. So I don't want to spend too much time on this element because I also believe that the law of genocide doesn't require the group to be destroyed, because what is important is an attempt to destroy that group, and not the fact how much they managed to destroy, during the time they had the opportunity. Because we have to remember that the deportations were interrupted by the Nazi aggression, and we don't know how many more waves we would have. So I'm considering that the requirement to destroy in whole or in part is also met. Now, the question of intent. This is the most difficult part and the most challenging in proving any genocide, I understand. We need a specific intent. So in other words, we need to prove to the court that those people who signed the death order, they specifically intended to destroy the Polish national group. And how can we do this? We can do it the easy way when they actually say that, okay? That's the direct proof. And then we can prove it indirectly. But when we prove it indirectly, we have to deal with the question of motive, which is a very critical issue here. But first I want to show you some straightforward proof. And I want to give you some quotes. The first statement Stalin made in 1937 when he was exterminating they called them Soviet Poles, because the Polish people lived on those lands for 1,000 years. And when Poland was reborn after partitions in 1918, many Polish people were left outside the new Polish borders, and they found themselves in the Soviet Union. So Stalin took aim at those Polish nationals during the so-called Polish operation between 37 and 38. And he killed incredible number of those people perceived as Poles, because it was enough to be a friend with a Pole to be already endangered. Not necessarily the Pole, but the collaborator. So what Stalin, Jerzów was in charge of the Polish operation, and he sent Stalin some reports how many he killed, how many portraits, because he sent portraits, like books of those exterminated. So he sent those portraits, like a couple thousands, to Stalin, and Stalin replied, and this is great, very well, keep on digging up and cleaning up this Polish filth. Eliminate it in the interest of the Soviet Union. I think this is straightforward, but this is 37, okay? Now, when they were negotiating the Ribbentrop-Molotov Pact, on the August 18, remember, the pact was signed on the 23rd of August 39, Ribbentrop-Molotov. On the 19th, Stalin had a meeting with his bosom buddies, with his Politburo people, and he said to them, and there is a record of that, it was published in the German press, in fact, and that's the quote from that, what he said: the first benefit from signing the pact, meaning the Ribbentrop-Molotov Pact, will be the destruction of Poland and the movement of our borders up to Warsaw. That's a really good deal. The other statement I want to bring to your attention is the fact that when they signed the Ribbentrop-Molotov Pact, they said that basically they agreed to divide Poland between themselves, but they left open the option of leaving some residual state, because there were so many Polish people that they, no one really wanted them. So they thought maybe we can leave some small place when we all those people will be congregated there, the ones that we don't want. But Stalin was the first one to alert Ribbentrop. Molotov conveyed to Ribbentrop in September that Stalin came to the conclusion that there is no reason to left any residual Polish state. So it was Stalin who decided that there shouldn't be any Poland. Of course, the fact that the execution order from March 5th has a specific language, using special procedure, apply to them supreme punishment, by execution by shooting. Okay, straightforward, intent to destroy. I want also to mention that there's a famous saying of Molotov on October 31st, when he referred to this unwanted child of the Versailles Treaty, but he put it much strongly than that. So those are direct proofs. Now let's go to what's critically important is the motive. Because the greatest objection to calling Katyn genocide is the argument, well, those people were killed not because they were the Poles, but because they were anti-communists. And this is the motive is absolutely the understanding of the motive. During the legislative work, there was a big struggle in coming up with the language of the definition. The Soviet Union wanted to list the motives for genocide and wanted to limit those motives. So in other words, if you kill for national, religious, or ethnic motives, that's what constitutes genocide. But if you kill for political motives, which is the big one, or for economic motives, or for personal motives, that's not a genocide. That was the Russian position. The British position was no, that's not right, because such a restrictive nature of the motives enables those who commit a crime of genocide to claim that they had not committed that crime on grounds other than the motives listed that the Soviets wanted to list. So it was clearly envisioned as a way out, as a pretext to cover up genocide. And they couldn't agree on that, and finally Venezuela came with the solution to reconcile the position, and they said this: okay, why don't we, instead of listing the motives, we use the words as such, and those words will mean that we do consider motives, but we do not list them, and we do not limit them. Okay, and basically that was adopted. That was the position that was adopted, that is in the definition of the Genocide Convention. It's critically important. It's absolutely critically important to the argument that is being made today that Katyn is not a genocide because it was committed for political reasons. Here are some statements from the countries negotiating the Genocide Conventions. And it's really nice to read it because it's a core problem that we have. And I think this really requires attention. Those who commit the crime of genocide may use the pretext of political opinion of a national, racial, or religious group to destroy it without becoming liable for international sanctions. Then another statement, a mention of motive is dangerous because it allows the guilty to exonerate themselves. So basically, this really was predicted by the legislators, by the creators of the Geneva Convention, Genocide Convention, that this position of the Soviet Union originally was aimed at way out of genocide. So we have a manipulation of the motive. Perfect proof in the preparation for the Polish aggression, when the Nazi and the Soviets were planning the Polish aggression. The Soviets came with the argument first that we will come to the aid of our Ukrainian and Belarusian brothers to defend them from Germany. And the Germans said, oh no, we don't like that language, okay? So then the Soviets said, okay, we understand your sensitivity on this issue, so we will no longer say that we are coming to protect you against Germans. So they dropped that language, okay? So, but they did not resolve, they are coming to protect the Belarusians and Ukrainians against whom? And it was brilliant because they actually said that they are coming to protect Ukrainians and Belarusians. And many Polish people felt that they are coming to protect the Slavic people against the German aggression. Either the Soviet soldiers thought that, and many Polish soldiers thought that, and they thought that they are coming as friends to help the Poles. You see? And only later it came out that they came to protect Belarusians and Ukrainians against the Poles. That was really brilliant because that was really that imprecise language enabled them to mix the national motives and the political motives and to cover up their real intentions. It was very misleading also for the Polish government. And the British ambassador at the time, I want to point to the last statement, the Soviet Union will be able to at any time switch from the defense of persecuted brothers to defense of oppressed victims of capitalism. And that's really what happened, because once it became obvious that the Soviet army came to obliterate the Poles, then the question was why? And that was a handy political argument, because all those Poles are anti-communist, capitalists, Catholics, religious guys, and we just hate them. I mean, religion component is very important because the Poles are Catholics and the Belarusians and Ukrainians are Orthodox religion. So there is a split on religion on that. So this was a brilliant strategy to be imprecise, and this has been even found in some specific directives. Now I want to go to the question is, the March 5th, the execution order, does that give us a clue of a motive? Did they spell out the motive? Why they wanted to kill those 25,000 Polish officers? And basically the key motive is they are saying that we are sentencing them to death basically because they are hardened, irremediable enemies of the Soviet power. Here we really don't see the motive clearly. It's not obvious. But then in other places of the language that this order uses, we have a group, former officers of the Polish army, former workers of the Polish police, and intelligence organs. This is clearly geared towards the Polish state, the workers and representatives of the Polish state, national motive. And then they use the phrase, various phrases, like very popular in this order and in many other documents. They call those enemies nationalist counter-revolutionary. And you have two components here, okay? Nationalist and counter-revolutionary. National motive and political motive together. They say anti-Soviet agitation, counter-revolutionary work. At the same time, national and anti-communist. So clearly the motives are mixed. But the courts clearly said, let me see. I think I probably moved, because what is critically important, because I think I skipped, I lost somewhere on the way, the concept of a mixed motive. Okay, and there is a clear law on the point that as long as we have a national motive or a genocidal motive, we may have many other motives, and it doesn't matter. Okay, as long as we find that national motive, then whether we have political or whether we have very big political or many political, doesn't matter, because we need just a proof of a national motive, and we do have that. Now, we need to, so that's my analysis of the motive. And it clearly the national motive is present, it's spelled out, and it is being proven in many instances. But I want to go also to the facts and circumstances, the so-called indirect proof of genocide. Indirect proof, so in other words, from facts and circumstances can we determine that the aim was at the Polish national group. And of course the Ribbentrop-Molotov Pact talks about this clearly. We also have this whole problem of the Katyn massacre in the context of the war of aggression. And in the criminal law and in the international law and in the law of genocide, this is a critically important context of this crime. And we also have, we must remember the secret protocol to the Friendship and Boundary Treaty from September 28, when the Soviets and the Nazis spell out their intent to suppress on their territories the agitation and resistance of the Polish national group. Not only that, but to inform each other concerning suitable measures. And they did cooperate very closely with each other to actually coordinate their action of exterminating Polish people, both on the Nazi side of the occupied Poland and on the Soviet side. I will not go into the details of that because Mr. Kenneth Ledford touched upon this issue very nicely in his presentation, so I will be skipping that. I only point out one thing, that at the time there were 4 meetings, top-level meetings between the invasion of Poland and the Katyn massacre. There were regular meetings of the top officials from Russia, from the Soviet Union and Germany on the conquered Polish territory to coordinate their action. What they did, we don't know, because the documents do not exist. We only have certain documents from the Polish underground, which is a secondary documents. So whatever they did, the fact is that Hitler authorized the so-called extraordinary pacification action, called as AB Intelligentsia action, on March 2nd. Yes, on March 2nd, 1940, and Katyn authorized, Stalin authorized Katyn killings on March 5th. Actually, he made that decision on March 2nd, according to Professor Lebiedieva in her group. The same timing. Okay, so basically, hatred, absolutely plenty of proof of hatred, and I don't have time to go to it. This is the illustration. This eagle, that's Poland. And Sovietization of the Polish lands occupied by the Soviet army, Polish language banned, Polish teachers thrown out, Polish books burned, Polish monuments destroyed. Kidnapping of Polish children, unknown story, but I just discovered one. This is just the scratching of the surface. Manifest pattern of similar contact. I will only mention that the Polish operation of 1937 preceded the Katyn killings, and then we have plenty of genocidal action in Poland after 1944, including the so-called Augustów operation, which is called a little Katyn or a small Katyn, which clearly meets the standards of genocide as well. Okay, with that, thank you very much.
Can we get our panel back up here? Please. So the question then for the panel, let's assume that was a prosecutor's opening argument. If you were the judges, would you conclude genocide based on that argument? If not, why?
Well, I would probably wouldn't go too much farther. I mean, I like the argument, and my compliments to our colleague. I like the way she hit all of the points that were necessary. I don't think she had to go that far, because again, in this situation, in this particular case, it's always nice as a prosecutor to have the smoking gun. Challenges that Steve and I had in Sierra Leone is they never wrote anything down. They only spoke to each
Humanity, let us recall, is what was prosecuted at Nuremberg. And when we've talked a lot about Nuremberg, I think if we're trying to highlight the hypocrisy of Nuremberg or what resulted from it in terms of the failure to address Katyn, what we really want to be doing is saying that if the Nazis committed crimes against humanity, which is what Nuremberg said, then maybe the Russians did too.
Bill, before you
Genocide,
go-
I know we're
before you go
talking about...
beyond that, I was going to ask you a follow-up on crimes against humanity. Under modern definitions of crimes against humanity, it has to be an attack against a civilian population. Since most of this was targeting military populations or former military with the intent that they not be able to rejoin the military, would that be a crime against humanity?
Well, these were civilians too, though. I think the point was made that there were many civilians who were killed, and many of them were reserve officers who were there, in fact, in as much in a civilian capacity as anything, because they were the intellectual leaders of the country. So I don't see a big problem with that. On the genocide, I think the difficulty is that the genocide requires demonstration of the intent to destroy the group. And you have to be able to make a distinction in law between racially or racist killing of people, which this may well have been. There's been a vivid demonstration of a racist motive, and the intent to destroy the group. And I think that's the weakness of the case that was set out. We have to have more evidence, and some things have to be explained, such as why did the Soviet Union agree then to reconstitute Poland subsequently, if they were so bent on destroying Poland?
Because they control it.
Let me jump in. First of all, on the crime against humanity issue, and I mean, I agree there's, the case is very strong for crimes against humanity, even though a lot of individuals were soldiers. And of course, one element is a widespread and systematic attack against a civilian population, and I think the kind of pattern of conduct which is laid out here would give you that context of widespread and systematic. And then each of these murders is a murder, is a crime against humanity. So I really don't have much question about that. I'm impressed with the argument. And you know, as a prosecutor, I'd like to bring this if I had an opportunity to do it. In part because, I mean, as David and I dealt with in Sierra Leone, I mean, we had individuals that we could show were, without question, guilty of, in our view, we had a strong confidence in our evidence, guilty of sexual violence, of rape, and of sexual slavery, but we also saw another crime there in forced marriage, which wasn't specifically written down, which we said this is another inhumane act under a crime against humanity, and we wanted to see if we could make some new law and establish some standards and push the envelope. You don't do that when you're dealing with somebody that you don't have anything else on, but if you've got solid cases on certain counts, pushing forward other counts to see if you can win them and establish a precedent that will be useful in deterring these crimes in the future, you do it. And we all try to do that, and certainly in the Yugoslavia Tribunal. great efforts were made in regard to crimes in which the Bosnian Muslim population were victims, to have those called genocide. The prosecutor was largely frustrated because judges would say this, going into a village and killing a bunch of men, women, and children, and then allowing others to escape in order to so-called ethnically cleanse, to drive people off 50, 60, 80, 100 miles away in order to establish your own sort of pure greater Serbia, to many people sounds viscerally like that's genocide, but that's not. That's the crime against humanity of persecution, maybe the crime against humanity of murder or extermination under certain facts. But then the prosecutor did at Srebrenica, in the Krstić case, and most recently in another case, Saksida Popovic case, and also the state court in Bosnia, the War Crimes Chamber, found that the killing of 8,000 men and boys at Srebrenica, when the women and girls and the very young boys and old men were put on buses and sent away to safety, at the same time, in another safe area some distance away, even though horrible things happened there, the same individuals weren't killed. The judges found that was genocide, because we do have this word in part. Mm-hmm. You destroy them in whole or in part. Now, I think figuring out exactly what that means. In the context of what happened in Srebrenica, the judges found that because of that population there, and because they went after all of the Muslims and men and boys, which were people of service age, potentially that could have had arms, that might have, but not certainly could have been involved in the conflict beforehand. But taking that group and killing them was genocide. I mean, I think that provides a pretty decent precedent for dealing with the genocide in the case of Katyn. Now, it's different, but there's also some aspects of it that seem to be even more aggravated in a way. And what we had here, of course, was as I see it, and I've seen this in other instances, a crime of decapitation. I mean, basically a selection of people who were the people on whom a free Poland would rely in the future, and they were destroyed. We see the talent and the brilliance in this group, and you feel the destruction of this people in such a significant part. I know, talking to somebody earlier, they said, you came here and you started talking about, Rwanda and all these other places, and we want to talk about what happened in 1940. But of course, we have to look at each of these cases and what they teach us. And we've had other situations that are reminiscent of this. I'm reminded in one of the crimes that had some role in what happened eventually in Rwanda. In 1972, the government facing the government of Burundi facing a small group of Hutus, which they quickly defeated. And the government in Burundi at that time was controlled entirely by Tutsis, only 15% of the population. They decided to launch a crime in which more than 250,000 Hutus were killed. Now, the Hutus were 85% of the population. They couldn't kill them all. But they killed all the government ministers who were Hutu. They killed all the military officers that were Hutu. They marched into the lycées and the schools, well, particularly the lycées, because those were kids that had gone on into high school, and they killed them, and basically created a situation of destruction of the ability of the Hutu population to act in the future, at least for a generation in that society. This is what they're telling me in Bangladesh, that just in the last hours before the surrender of the West Pakistani forces, these various militias went out and killed professors. They killed professionals. They killed essentially the cream of the society. Even though they were going to lose the war, they didn't want this country to go on. Those are aspects, I think, that suggest a desire to destroy the group in part, as such, et cetera. that I think could give you an argument that you've got genocide here. Now, again, I don't want to, if I went to court and I filed this, and if at the end of the day they gave me 21,857 convictions for crimes against humanity, I wouldn't be angry. But I do think that with genocide, given certainly what's been established at Srebrenica, this would be worth a try. Thank you.
David, David, you indicated you wanted to add something?
Arguable genocide, but I think Stephen makes another very good point, and that is that what we're here is to seek justice for those who have been destroyed horribly. Again, we're always kind of leaning towards genocide because it in your minds it captures what you think is probably the right thing to do, but in reality, from a legal point of view, and Bill makes very important points. In my mind, if I was a prosecutor as well, I would, in this modern era, I would have charged in the alternative so that I would get a conviction as opposed to, let's say I just charged genocide. We just took the Katyn massacre and we just charged him with genocide, and if I don't prove that special intent, I'm out of court. There's an acquittal. So what we did in Sierra Leone, and it's a smart prosecutorial move, I'm sure you did it in Iowa, Steve, is you charge in the alternative so that it gives the trier of fact, be it a jury or be it a tribunal, it gives them an ability to plug in the facts as have been proven into the crime that has been charged. So that if by chance, through the evolution of a court process that can take sometimes years, genocide seems to drift, we find things that it isn't going to raise to that level, you still have crimes against humanity. And I think that that's very important, and that when we're considering Katyn, you shouldn't feel badly about that, because there has been justice done, that it's a crime against humanity, and that there has been justice. And because, again, it goes back to my semantic indifference tier level. Is genocide a more serious crime than a crime against humanity? In my mind, as a former chief prosecutor, it's not. It's about justice and making sure the facts are appropriately presented beyond a reasonable doubt, so that there's also an appropriate historical record related to what has taken place.
Just one point on the legal thing, and it may be relatively unimportant, but you know, I believe in charging all of the crimes that apply, if you can. I mean, not necessarily every crime site in every case, but if you, and at the Rwanda Tribunal, we almost always got convictions of genocide and crimes against humanity murder and crimes against humanity extermination, and if we had an armed conflict aspect of that particular thing, we sought a war crime for murder. The law is that you can get multiple convictions for the same act as long as the elements are different and you prove each of those elements. Now, if the elements are exactly the same, you can't. And so, but we want to reflect all the criminal conduct. Maybe that's piling on. It doesn't add to the sentence or anything, but it still gives the world more guidance when they've only got part of that in the future. So we seek it all.
I want to let Bill interject, but I also want to ask you a question to address at the tail end of your interjection. Twice now, David Crane has asked whether genocide really is hierarchically superior, worse crime. And you wrote a book on genocide that you called The Crime of Crimes, which seemed to indicate that it was somehow worse than other crimes. And I wonder if you would comment on that as well as whatever you were about to say.
Well, I was borrowing the expression from the judges at the Rwanda Tribunal, who used it to speak about the crime of genocide. And I think I was making an observation that's not so much a legal observation as one of policy. Because as the judges now have pointed out at the ad hoc tribunals, one cannot determine from the statutes of the tribunals that there's a hierarchy between the crimes. And it's really more a question of, and this is one of the great difficulties we have in international criminal law generally, when we get into this exercise of trying to compare crimes as to which is more serious and which is less serious. I don't know how well it goes over when Robert Jackson says we didn't, you know, it wouldn't even have been a good thing to prosecute Katyn against the Germans because we had more serious crimes that were committed against the Poles, where many more people were killed. But we do make those kinds of determinations, and I mean, I'm feeling a bit lonely here, surrounded by all these prosecutors. Actually, but the prosecutors make these determinations. I want to make a point though about because the prosecutorial framework is only one way of approaching this question, and I want to give an example of victims of terrible crimes in recent years who were very wedded to a narrative where their victimization was described as genocide. And I'm talking about the Bosnians. And the Bosnians were so determined that they went to the International Court of Justice with a case that they lost, essentially. It's true that the International Court of Justice confirmed that the Srebrenica massacre, that they would endorse the findings of the International Criminal Tribunal for the former Yugoslavia, labeling that genocide. But the war itself, they said, was not a genocidal war, and that was a devastating blow for them in a moral sense, in a political sense. It was a humiliation for them, and it was because they asked for too much when you had a difficult legal argument to make. And so here, this is not a court. I would say if the victims of Katyn are thinking of going to the International Court of Justice to make out a case that they've got genocide in 1940, aside from the temporal jurisdictional issues, they ought to think very carefully, because the worst thing for the victims would be to try and fight that battle and lose it. With crimes against humanity and war crimes, you've got a battle that's easy, that's simple. You've got that one, and it's not always. It's one thing for prosecutors to say, it's okay. I'm wearing suspenders and a belt, so the belt, the belt breaks, my trousers aren't going to fall down. That's fair enough. That's their strategy, really. But when you're talking in the realm of the describing something in a political sense, in a theoretical sense, and one that has great consequences for the victims in terms of their perception, I think it's better to invest in trying to in the clear argument, saying these were crimes against humanity, just like Nuremberg, and not to try and push an argument that's fraught with difficulty.
And can I ask you a follow-up on that? It's sort of a twist to that. Robert Petit, who is the former prosecutor of the Cambodia Tribunal, spoke at this law school. Many of you actually, I think, were there. One of the things he said was that there was extreme pressure on him to indict for genocide, and that he was not sure that the case of Cambodia technically was a genocide. And he said that he is afraid of two things. One, losing the case, which is what you were just suggesting. But he said he was almost more afraid that he'd win the case and there'd be bad law made. What's the implication there, Bill?
The concept of genocide and crimes against humanity is something that has been in flux since the words were invented. Both terms within a few months. Genocide, by the way, as you all know, was invented by a Pole, Raphael Lemkin. Crimes against humanity, by the way, was proposed to Robert Jackson by Hersch Lauterpacht, who was born 30 kilometers north of Lvov, right? Mm-hmm. So they were both from Poland, actually, Lauterpacht and Lemkin. And those terms were created at about the same time, and they've had this strange relationship between them for the past 65 years. And that could continue. But I think what's happened in the last 15 years or so is that the pressure to expand the definition of genocide, either by amending it to include political groups, which had long been proposed, or just to amend it in terms of expansive interpretations by judges, has been resisted generally by that. Generally. There are examples to the contrary, but someone looking at all the cases would say, generally, judges have been conservative on this. At a time when they haven't generally been conservative, and where they've given broad, expansive interpretations of crimes against humanity, something has happened, for reasons that I don't fully understand, but where we've decided to kind of leave genocide alone and put all the energy into expanding the definition of crimes against humanity. Why that's happened, I can't explain, but that is what's happened legally. And if you had to choose between one of them, I'm sure my prosecutors would agree with me. If I gave you a choice, you've only got one, you can only put one charge, you wouldn't put genocide.
No.
But in alternative, you would.
Of course.
And,
If you had these facts.
because I think the issue that to me seems to be a difficulty is that we have several types of perpetrators. And clearly, for some, genocide would not apply, probably for those at the lower levels, those who actually implemented the killing, and those who were actually charged in the Russian prosecution. Those were the people who executed the order. So in that sense, for those perpetrators, I absolutely agree that this qualifies as a crime against humanity, not a genocide.
Can I add something? As this issue is unfolding and as people continue to reflect on how to deal with this legally, may I suggest that great attention be paid to the case law of the European Court of Human Rights, where there have been a number of cases. We have 2 Katyn cases now before the European Court of Human Rights, but there have also been many others dealing with atrocities from that period, both post-1945 in places like Estonia and Lithuania, and pre-1945 during the war. There's a very important decision from 8 months ago from the European Court of Human Rights, Kononov versus Latvia, of the Grand Chamber, which is like the Supreme Court there. I know this case well because I was the counsel to Latvia in that case. And in that case, Latvia had prosecuted a pro-Soviet partisan for atrocities committed in the Second World War. And the Russians who intervened in the case argued that there couldn't be war crimes committed by the Russians because only Nazis could commit war crimes in the Second World War, was essentially their position.
Yeah.
And, well, you laugh, but they lost.
Okay.
Latvia lost at the chamber at first instance 4-3. And then I got involved after that in the case before the Grand Chamber, and it was 14-3. But 3 judges agreed with the Russian argument, including the French judge. So, it's not a straightforward. I mean, you laugh, but it's not a straightforward argument, but it's an important precedent. And there will be other cases. I think that Kononov is extremely helpful in terms of framing a case about Katyn, for example.
David, want to add something?
Just real quickly, Steve brought up the challenge we found in West Africa when I originally arrived there. We had bushwives that were used throughout the conflict up to the tune of over 35,000 women who were bushwives and girls. And we had a statutory listing of the things that we could charge: rape, sexual slavery, etc., terrorism, enslavement. But the facts didn't fit. There was something, it was a greater crime. And so I remember sitting around in a round table with my prosecutors. We just threw it on the table and said, I think there's something greater here. And then we just chatted. The beauty of crimes against humanity, at least in our statute, is and other inhumane acts. And so we focused on that and said, well, this is another inhumane act. And we all felt that legally we could amend the indictments and get another charge put in. And then it was going around the room, well, what do we call this then? We can't just call it bushwives. So it was amended to other inhumane acts, and then we described the bushwife phenomenon, and it was upheld throughout, and Steve successfully finished up the prosecutions and got convictions, some very key convictions on this new crime against humanity called forced marriage in times of armed conflict. So the crimes against humanity kind of tier allows a prosecutor to fit the horror, the atrocity, the circumstances that you're faced with a little bit better. Genocide is very clearly defined and boxed in, whereas you can have much more flexibility with crimes against humanity. And then we're not talking about war crimes here, but that's a whole another thing.
No.
I do want to add something about it's important to understand that the law is constantly developing, both in terms of construing these conventions and determining what custom is. Do keep in mind that crimes against humanity don't come to us at least until the Statute of Rome in 1998, as written down by a Congress or a legislature anywhere. They're a matter of sort of determining what the law of civilized people was at the time of their commission. And so it's a challenging thing that we faced on crimes against humanity, and even like crimes against humanity in dealing with the issue of bushwives. We had it also with war crimes and child soldiers, because we had to show that that by the 1990s, employing children under the age of 15 in military operations had become essentially a violation of the law of civilized nations. And things do develop. One of the more intriguing things about Nuremberg, which always comes as a bit of a surprise to people, is that the crimes that were prosecuted in Nuremberg couldn't really include, and I could be corrected on this, crimes against the German people by the Nazi government. The crimes were, at that point, the Geneva Conventions applied to international armed conflict, and the war crimes are basically crimes against people of occupied countries. And crimes against humanity under the Nuremberg statute had to be tied to other crimes under the statute, which basically required that to be coincident with one of the war crimes. And so the murder of 180,000 German Jews is really no part of the convictions at Nuremberg. That was still the law when the ICTY was established. That essentially the ICTY was only able to do crimes against humanity to the extent they related to war crimes. That prohibits the prosecutor now from dealing with certain crimes against Serbs in Kosovo after the withdrawal of Milosevic's forces in 1999. But since that time, in the Statute of Rome and in the other courts, we've now clearly established that crimes against humanity don't have to be tied to a war crime. Additionally, war crimes since 1949 and Common Article 3 of the Geneva Conventions, and particularly with the additional protocols, now can apply also to civil wars. And indeed, what's happening in much of the world now in terms of the worst atrocities, it's not in cross-border conflict. It's in places like the DRC and elsewhere. We're in Rwanda with the genocide, with 800,000 people killed in a conflict that probably saw fewer than 100 soldiers die. And so it's in those places that you now have it. So the law develops, but I think as we deal with crimes against humanity, and we saw that in the media trial, I wanted to make sure that if I couldn't prove these people guilty of a genocidal campaign through the media, I could show that the media had been used to commit persecution as a crime against humanity by going after Hutu moderates, for instance. And so it's important to look at what you've got there and have the tools available. And I agree with Bill that it's in the area of crimes against humanity where we've seen the greatest expansion of the law, but even then, I think it's important that where the facts can fit genocide, that we attempt to convict for that as well.
Now, Bill did.
Excuse me, just real quickly. As a footnote, and I don't want to make you lose control here, but it just came up as I was listening to both of you. Yesterday afternoon, as I was flying down here from Syracuse, I said, "What would have happened if I'd have been a chief prosecutor? I just got appointed by the League of Nations or whatever, and I was dropped right into 1943 and said, prosecute what took place at Katyn." And I thought to myself, what international law was actually available to me physically at that time? And I was really kind of struck by, I thought immediately, well, certainly, probably not, Nuremberg doesn't exist. We have to just take that whole concept out. What would I have actually used as international law to prosecute the Soviets for what they did? And I ended up coming up with probably a violation of the laws and customs of war. And then I thought, well, what else? And then I went back to some of the things that were coming out of World War I and some things, three pashas and some allegations against the Kaiser, and I came up with potentially what at the time they called it crimes against civilization, which is kind of like a crime against humanity. But I kind of stopped. I mean, that was kind of the international kind of recognized law that was floating around at the time, at the beginning of World War I, is yes, if it was a war, there were certain courtesies that were extended to prisoners of war, et cetera, and certainly you couldn't intentionally target civilians, and you had to conduct your military actions using military necessity and proportionality and discrimination, and you couldn't use weapons that would cause unnecessary suffering. But actually trying to, if I said, all right, these are I have Beria in my custody, and what would I charge him with at the law of the time? And I came up with just kind of like two things, violations of the laws and customs of war, and maybe try to get something called crime against civilization. But again, I found it kind of striking as to how much we have come since that time, and that now, as prosecutors, we have a lot more tools in the past 15 years in the jurisprudence and the precedent that's available. But I just thought I'd just throw that out there as how little that we would have had if we would have just dropped right in.
If I can comment on this, because from what I understand, and I don't have the text of the preamble to the Genocide Convention, but the preamble of the Genocide Convention recognizes this problem and spells out that genocide has been the crime this is the crime that has been with us since the beginning of humanity.
Right, that's a good point.
At all periods of human history.
Exactly. So it is only at this point that we are defining it in a legal language, but it doesn't mean that it didn't occur and it didn't happen before. And by that preamble language, we are pulling the crimes of the past within the scope of the Genocide Convention.
No, but what I was just saying is that would have been, at that particular moment, probably a crime against civilization with the same idea, because again,
and don't forget, David, that at Nuremberg, they had the same issue that you're talking about, but they were very ambitious and creative in creating the Nuremberg Statute to define the crime against humanity, and the Nuremberg Tribunal said, even though this is defined in a charter for the first time ever, we don't think there's an ex post facto problem, because, and they had very creative thought. They said if one murder is a mala in se crime, then surely 100,000 or 1 million murders also must be.
Well, I don't disagree. They just took crimes against civilization concept and turned it into crimes against humanity. It's the same crime, I'm thinking.
But now let me move to another question, so because we're running out of time. Bill, you did tell us one unique reason why it might be important to label that genocide, and that is that if you wanted to get a case to the International Court of Justice, the only vehicle would be through the Genocide Convention. But you've mentioned the risks that you might lose on the merits, and also that the Genocide Convention might be interpreted as not applying before it came into force in 1948. But let me ask, if we take away that, what are the other mechanisms that would be appropriate? Tomorrow, Alan Gerson's going to focus on civil liability, so we won't focus on that now. But what about new ad hoc tribunals or truth commissions? Bill, you were on a truth commission. Or UN experts bodies, or US congressional action, like in 1952. What are your thoughts on these other mechanisms?
Who wants to? You've been there.
Well, first of all, although there are things about the crimes that we don't know, we have an admission now by the Russians that they did it. I don't know that we need inquiries now to get to the bottom of that. There may be other facts that we'd like to develop, but I think that largely we agree. I mean, I haven't heard anybody here in the room. I realize this maybe is if we had a room full of Russians, there might be a little more argument. But I doubt it if they were sincere and intellectually honest that we'd have much argument. As I say, they have admitted it, and we have the documents. I think the question really is whether you want to actually hold individuals responsible before criminal courts, and that's an option. There are still some people alive who could be prosecuted, although probably the numbers are dwindling and will continue to do so. In the case of the Armenians, they debate this, and they recognize that really there's nobody left alive who could be prosecuted for the Armenian genocide, but that's 25 years earlier. I would say also on the International Court of Justice, just not wanting to leave that for a minute, no state has ever done this, but the International Court of Justice has jurisdiction over customary international law as well as over treaty law. And I've never seen any good reason why one state couldn't sue another for committing crimes against humanity. So that even if there are difficulties with genocide as a legal concept and getting it to fit, based on the existing case law of the International Court of Justice, the possibility of a case under crimes against humanity is also an interesting one. Just one last
Russia
point.
and Poland party to the
We have to
compulsory
check
jurisdiction?
how much they've accepted the jurisdiction. I think Russia has accepted the jurisdiction.
The compulsory jurisdiction.
No, not the Statute of Rome, the compulsory jurisdiction of the International Court of Justice, because they were sued by Georgia.
Right.
Remember?
So Russia.
Everybody knows they were sued by Georgia a couple of years ago. So I think you can get Russia. I don't think that's a big obstacle. I want to say as well about the retroactivity, because this was David's point. It's true if you arrived in 1943, you'd be in the same position as the UN, as the United Nations War Crimes Commission and the Allies. You would have to make up the law. But they did make it up. Now, if we look at 1940, there's no problem with retroactivity. There's no problem with crimes against humanity, war crimes, or genocide. It's not a problem. That's been established. If you want to go before 1939, you may have some arguments, but there's no problem with 1940. The problem with genocide is not one of retroactivity. It's just about fitting in the definition. Crimes against humanity, it's now well established, and the same with war crimes. So I wouldn't, I'm guilty of this now, I wouldn't waste any more time on the retroactivity issue. I don't think that's a problem at all.
Stephen.
If I could ask Bill your question, what would you consider the weakest point to fit into the definition of genocide?
Well, I don't have a case
Sure, but
that supports
yeah, based on our
this.
discussion today.
The weakness is, and this was where the Srebrenica case crossed over the line. The Srebrenica, the International Court of the International Tribunal for the former Yugoslavia said, and it was confirmed by the International Court of Justice, is that they were trying to exterminate Bosnian life in a small community. It wasn't that they were killing 7,000 people as part of the Bosnian masses. It was that in the particular circumstance, it was genocide because they were trying to destroy the community. So what's the community that the Russians were trying to destroy when they murdered the men at Katyn? And I think that's the weakness.
Can I reply to that?
Sure.
This is not an element of the crime, but the proof that the genocide has succeeded. Because if you look at the territories we are discussing today, which is Eastern Poland, which has been incorporated to the Soviet Union after Yalta, okay? Today, those lands belong to Lithuania, Belarus, and Ukraine. And we have a clear proof by looking at those lands that the Polish national pattern on those lands has been destroyed. And that is what genocide is supposed to prevent.
That's what Lemkin said. But it's probably not the prevailing interpretation of the convention to say that you're destroying the life in the community. It has to involve the physical extermination of the people. And, you know, I'm not trying to argue in a way for one side or another. I'm just trying to be what an academic's supposed to be, is to look at everything in a balanced way. I think there are, you asked me what the weaknesses are, and those are weaknesses. And you have to bear in mind, we're not just talking about a definition, but we're talking about case law. We have a lot of case law now. And it's not that helpful to you, I don't think. I agree with Steve that the Srebrenica thing opens a door, but Steve, it's just opened a crack.
No, I agree that it's just opened a crack, and I agree with Bill that as horrendous as it seems to essentially remove Polish life from this part of what had been Poland. We obviously have all of these decisions that have held that the efforts to, say, create a greater Serbia by cleansing and moving everyone out through acts of murder wasn't a genocide. It took in the case of Srebrenica, this destruction of this specific community. And it's in that area where I'm trying to say that in the sort of selection of this group and the decapitation and the sort of way in which it was done, that you could you can find an analogy, and you may be able to succeed. Not to constantly go off into different situations. I mean, the issue is very alive today in Darfur, where, as you all remember, the prosecutor sought an arrest warrant against Omar al-Bashir, the president of Sudan, in July of 2008 for genocide, crimes against humanity, and war crimes. And then in March of 2009, the pretrial chamber said, no genocide. You know, you don't have, you've got, you know, you've got Darfuris living safely in Khartoum. You didn't try to kill those.
But then didn't the appeals chamber?
And then, indeed, the prosecutor appealed that, and the appeals chamber gave him an arrest warrant, or ordered an arrest warrant, charging genocide. In that kind of situation, where indeed the attack is in a specific area, not all Darfuris are targeted. People, in many cases, are moved further out. You know, one can, I think, argue that what's happening there is they're being moved into places where the conditions of life are uninhabitable, and it's like killing them. And the international community comes along and provides aid to help them not die.
But the appeals chamber didn't issue it. They just said that the pretrial chamber set the bar too high.
Yeah.
Take a lower standard, and we'll let you try and prove it. So it's not very compelling.
No, indeed, and here I should yeah, exactly, Bill. This is not Omar al-Bashir is not before the court physically, and if he were, there'd be an opportunity to fight first of all whether an indictment will be confirmed on that grounds, and secondly whether he'd be convicted on it. This is just the first step. But the prosecutor now has an arrest warrant against Omar al-Bashir in a case that frankly draws a new line. And so, as I say, the law can be moved in this area using the precedents that we've seen.
Let's open it up to questions from the audience. You've been so patient, and as the last panel, look at all these questions. All right, wait for the microphone, because there are still people upstairs, and people are watching this all over the world because it's being webcast. And then as soon as the microphone comes, identify yourself, ask your question, and we'll have a response.
Yes. My name is Gene Bach. I'm Polish American Cultural Center. And I'm a little troubled with Professor Schabas' statement when he says in 1946 Stalin decided to let Poland exist, even though as a communist country. I think you have to look at it that at the beginning of the war, when the Russians came to the eastern part of Poland, there was a different approach to eliminate all Polish elements from that area of Poland. Stalin made a statement, from what I've read, is that let's eradicate the bastard child of Versailles. Now that's a much stronger statement that Maria made a little while ago. So the issue of Poland being allowed to exist in 1946 should not enter into the fact that that Stalin had an intent to eradicate all Polish people from the area that he controlled. Of course, he couldn't do anything on the German side because that was up to them. So we have clear intent to eliminate the Polish elements, Polish nations, Polish people from that area. So in my estimation, it was a clear intent, and therefore it would fit the definition that was presented to us by Maria. Thank you. And I'd like your comment on it, please.
Well, I'm making my comment on this in light not only of the definition, which we all can read, but the way it's been interpreted by the courts. And the courts have said that the attempt to, or the destruction has to be the physical destruction in terms of the killing, the extermination of the people. That's basically the gist of all of the modern case law. And there have been sharp disagreements, because we have at the Yugoslavia Tribunal a dissenting judge in the Krstić case, Judge Shahabuddin, who says, no, it's broader, but that's rejected. So we have a lot of case, we have case at the European Court of Human Rights as well. We've had a lot of case law that sharpened our understanding of this, and the majority of the case law holds that it's got to involve physical extermination. So if that's the case, the statement by Stalin in 1939 to destroy the bastard child of Versailles is about eliminating a country, but not about murdering the inhabitants of the country. And you may think that it's desirable that the elimination of a country is also deemed a genocide, but I'm just saying realistically, in light of the case law, you have to find evidence of the physical extermination. I would say if Katyn is really the strongest evidence we have of physical extermination, you ought to stand back from that assertion and say, well, does that really hold up? Is that what the intent was? You have to exercise caution on all of this, and I mean, you use the word clear and everything, and everyone says it's a clear case, and maybe it's just the natural reaction of a legal academic and a practicing lawyer, is nothing's clear. Things aren't clear, and this one isn't clear either. So when I say, you ask me what are some of the weaknesses, and I say, okay, you have evidence that they tried to destroy Poland in 1939, and I have to take that into account with the fact that at some point Poland returns, and I don't see this animus in the Soviet Union of wanting to destroy all the Poles. So how do you explain that? How do you explain, if they wanted to destroy all the Poles, why did Poland revive?
How about with the Jewish people? They still exist because there were too many of us.
Just very quickly, if you want to
Very
respond.
quickly, yeah. The deportation of people from that area to Siberia was, to me, and I was one of them, okay, a clear indication that they wanted these people dead. Maybe not dead on the spot, because they still wanted to use them for some useful purpose, but people don't survive gulags that well. Thank you.
And if I may come, can I?
Okay, go ahead.
In my analysis, I presented the focus on killings when I discussed the genocide. But in the presentation on the scope of the crime, I was trying to show the close connection, actually, that deportations and killings were the two types of genocidal actions performed or executed at the same time. So they need to be looked at together. And due to time constraints, I just had to limit myself.
Would you like to ask your question or make a presentation?
Because of my poor English, I will. Sorry. Because of my poor English, I will speak in Russian. Please excuse me, with the help of the translator.
Okay.
Как представителю страны, которая совершила это преступление.
As the representative of a country who committed this crime,
возможно, мне следует молча выслушать мнение столь авторитетных специалистов.
I probably ought to listen to the opinion of all the authoritative specialists in this area,
Тем более, что я не юрист.
especially that I'm not a lawyer.
Но как представитель общества «Мемориал» хотел бы высказать наше отношение к квалификации как геноцида.
But as a representative of a memorial group, I want to express our attitude toward this classification as a genocide.
Прежде всего, по существу, катынское злодеяние действительно, с нашей точки зрения, носит признаки геноцида.
Katyn crime, by its by its essence, has their characteristics of genocide.
Однако эта квалификация катынского преступления уязвима с узкоформальной точки зрения.
But this classification is very arguable from the formal, very narrow point of view.
Единственный документ, на основании которого можно рассматривать мотивы.
The only document that shows the motive,
Это записка Берии, о которой здесь уже говорилось.
it's notes of Beria, or one note of Beria that was mentioned today earlier.
В этом тексте непосредственно, прямым образом, названа только одна мотивировка расстрела.
In the text of this letter, there was only one motive named,
Политическая, исходя из того, что все они
political.
являются закоренелыми, неисправимыми врагами советской власти.
Political motive based where it was said that all Polish prisoners of war were they were the enemies. Yeah, no, I'm just trying to see. Maria, you had it in your presentation. It was like unchangeable and rooted enemies of
We
Soviet.
have a text original in our booklet, so I think that would be good to refer
Yeah,
to.
and the booklet that they were irredeemable enemies of Soviet power.
Этнический признак в этом тексте упоминается не как, формально, не как причина, не как мотив расстрела, а как одна из характеристик.
Ethnical feature in this note is mentioned not as a motive, but as one of the characteristics
Вот той группы, о которой Берия доносит Сталину.
of this group that Beria was telling to Stalin.
И таким образом этот документ дает возможность нашим оппонентам, а я имею в виду прежде всего российскую главную военную прокуратуру.
And that's the opportunity for their opponents, who is actually the chief Russian prosecutor's office, the opportunity to
Ссылаться на узкую трактовку определения преступления геноцида, которая дана в Конвенции 1948 года.
to rely on the narrow definition of genocide in the Convention of 1948.
Я говорю с точки зрения нашего противостояния с прокуратурой.
And he's talking from the point of view of their conflict with the opposition with Russian prosecutor's office.
И мы видим, что этот спор вокруг квалификации как акта геноцида очень выгоден прокуратуре российской.
And we see that it's to their benefit to keep arguing about this definition of genocide.
Потому что дает ей возможность сосредоточиться на опровержении этой квалификации, что нетрудно сделать, если ограничиться узкой трактовкой конвенции.
Which is easy to deny this qualification if to apply the narrow definition of convention.
И таким образом уйти от неудобных для прокуратуры вопросов, которые мы считаем очень важными.
And that way, the prosecution is trying to avoid discussion of the really important issues.
Прежде всего, опровержение срока давности.
Which is actually the statute of limitation, which they keep denying.
Юридическое признание расстрелянных жертвами политических репрессий.
And the legal recognition, which was made by the victims of the political repressions.
Юридическое установление в качестве виновников Сталина и членов Политбюро.
And a legal establishment that the Stalin and Politburo were the real perpetrators of this crime.
Вот дискуссия, спор вокруг квалификации как геноцида дает, облегчает им уход от этих вопросов.
Therefore, they just avoiding the discussion of real issues by just arguing over the genocide application.
But it's actually, he's saying that the debate about this issue is making it easy for them to evade the real issues.
Я уже кончаю.
He's finishing.
Only some words. Квалификация по пунктам Б и С статьи 6 Устава Международного военного трибунала.
The classification of the Article 6 of International Military Tribunal,
Points B and C.
points B and C,
Как военное преступление,
as a military crime
как жестокое обращение с военнопленными.
and
Cruel,
cruel treatment of the prisoners of war
и преступления против человечности,
and crimes against humanity,
жестокое обращение с представителями гражданского населения.
Cruel treatment of civil population.
Прокуратуре оспорить гораздо труднее.
It's way much harder for the prosecution to challenge this.
Аргументы у них значительно более слабые.
And they have very weak arguments.
Поэтому, на наш взгляд, спор, была ли Катынь геноцидом,
And therefore, the dispute whether Katyn crime was a genocide
для нашего внутреннего противостояния
for our internal
с прокуратурой,
arguments,
это тупиковый путь и бесплодный.
it's a dead end.
Потому
It's
что
not leading anywhere.
Потому что квалификация по пунктам Б и С 6 статьи Устава Нюрнбергского, она решает вопрос о неприменении срока давности.
Because the real issue that the classification of the Article 6 of the Nuremberg
Charter of the Military Tribunal.
of the Statute of the International Military
Tribunal at Nuremberg.
the tribunal talks about the statute of limitations, actually, that it's not even applicable
Right.
here.
Right.
Thank you very much.
All right. Now, this is what we're going to do because the time is running out. I'm going to have everybody who wants to ask a question limit it to a minute, and everybody gets to ask it in a row, and then I'm going to have the speakers pick and choose among them, and we'll just finish up right at 5:15 as suggested. So let's start back there. There's a lot of you, so keep it short. Can you guys keep notes?
Krystyna Piłkowska, Muzeum Wojska Polskiego. We're going to shoot, but one of the questions is from the professor as well. An item which has remained unmentioned today and should have been mentioned is the Polish population of Eastern Poland that was renationalized as Soviet citizens after the invasion and was then arrested and charged with crimes as Soviet citizens. If they were not to be considered Soviet citizens, and that's possibly why also the base of people that were transported out of Eastern Poland, quote, supposedly is lower. If these people were then to be considered as what they really were, Polish citizens, would that not aid in the issue of crimes against humanity? Am I making sense to you? Are you understanding what I'm saying?
Mm-hmm. Okay, well,
That's the one thing. The other thing about discussion of 1940 and not knowing what law would be applicable, the Wehrmacht Allied War Crimes Bureau, which existed since World War I and continued in operation in World War II, was the agency which was investigating the Katyn crime. So my question to you is, what law were they operating under in World War I and then in World War II? Thank you.
okay, we're going to continue to take the comments and questions. There's one back there. Please keep them very short.
My name is Irv Feldman. in light of what we've heard today, and in light of the fact that Poland could probably achieve a lot of political leverage by bringing a suit today against Russia in some international court, why is it that Poland has not done that yet? Is it a matter of not having enough evidence? Is it a matter of fearing the outcome? Is it a matter of pressure from other countries? Is it a matter of Russia being so big and having the atomic bomb, or something else?
Right.
Okay, that gentleman there. And we'll get there too.
Mr. Adamczyk alone, and the purpose of this conference seems to me is to lead us to, maybe this is for tomorrow, accountability and closure. Where do we go from here? My sense is the last question, along the same lines of the last question, what are the legal and the political options? Should we pursue a case in the International Court of Justice? So do the cases in the Strasbourg court have any legs? The Russians haven't, shouldn't they be accountable politically? They've made some progress, but we've heard a lot of things the other way. And a lot of Poles, I am merely a son of Poland, I'm a Polish American, but I know a lot of people in Poland feel strongly about the U.S.'s response, not only in the war, but in Katyn. Should the U.S. politically have a bit of a mea culpa at some point?
Down here.
My name is Rudra Kumar, and I'm a Tamil from Sri Lanka. This is for Ambassador Rapp. Regarding what happened in Sri Lanka during the last phase, the State Department initially characterized as alleged war crimes. Now they also characterize as crimes against humanity. Will you go to the extent to characterize as a genocide, given the fact all the victims are Tamils and the perpetrators are Sinhalese? And if I quote the ambassador, the Professor Williams thing, actually it was physically destroy the community that lived in the rebel control area. That's a question and a brief observation. I think whether you characterize it as a crimes against humanity or genocide, you said it may not, it doesn't matter, but what matters is the remedy. If you characterize it as a genocide, the remedy might vary, because then that concerned group can say, okay, we have to live, we need a separate country. In fact, in the Kosovo case, the ICJ briefly touched that issue, but then they said that was not within the jurisdiction, so they didn't do it.
Do we have one more question? Okay, last question.
Can it be inferred that the lesson of Katyn is that powerful countries can commit war crimes and be immune from prosecution?
All right, so panelists, we have 5 minutes. If you'll each speak for about a minute and answer whichever question you prefer, or tie up your comments as you want. We'll start with Maria.
Yes, I have a quick answer to Mr. Feldman, I think. Why Poland hasn't prosecuted this case on the international forum? To me, this is just a proof how effective the decapitation of the Polish nation was.
Okay. Ambassador Rapp?
Yes, well, I had the specific question on Sri Lanka, and obviously it's hard to answer in 1 minute. You can find the reports that my office and the State Department did on the crimes. We're still waiting and pressing for accountability for what happened there. We were not called upon to make a legal conclusion, but to lay out what evidence we had and what kind of crimes they could be. And that certainly included war crimes and crimes against humanity. The genocide question is a more complicated one in this situation. Obviously, there was an impact on exclusively Tamils during this period, but there were many other Tamils in other places that at that period weren't attacked, and at the end of the day, even though we had this long period of detention, Tamils are released. And so it's one of these situations where, as we look at the law, it would really be beyond where the law is now. So that's not how the people have focused on it. Finally, in regard to this question about can powerful countries commit war crimes, well, the important thing is, as we've developed international humanitarian law, is to recognize that these crimes exist. I mean, that these sorts of conduct violate the laws of all nations, and that for a country to attack an unarmed civilian population, even within a civil war, is not a domestic matter anymore. It's an international matter. To commit crimes against humanity or genocide within your own country is still a matter of international concern. And however, the system in the world is that, and recognized by the ICC statute explicitly and by custom universally, is that the obligation is first and foremost on the states themselves to prosecute. We have in America a system of war crimes prosecutions and court-martials for military individuals and other cases where we do prosecute officers and others that commit these crimes. And it only goes to the international level when there's no will or capacity to do it. But I submit that the law applies. It, however, isn't uniformly enforced in every country, and that's why we're continuing these international efforts to ensure that it is.
Bill Schabas.
Well, the question of there being justice for small countries or for losers in wars and not for the big countries is one of the great mysteries of international criminal justice, and it's a work in progress and it's unresolved. At Nuremberg, Jackson explained when he was questioned by the Select Committee, why didn't they prosecute the Russians for Katyn, and the reason was that they had no jurisdiction because they had defined the tribunal as being only for the major war criminals of the European Axis. That changed at the Yugoslavia Tribunal, where it was any crime committed on the territory of the former Yugoslavia, and as Steve explained earlier, the U.S. had a bit of a close scrape there, not that they probably would have been convicted, but certainly to the surprise of many, it turns out the court did have jurisdiction over the acts of the American Air Force in Kosovo or in Yugoslavia in 1999. My commitment to this whole process is because I believe that one day we really will have a genuine system of justice that works against the big countries as well as for the weak ones. But it's something that we have to struggle for. I think that Katyn is a good example because I think you've got the Russians by the short and curlies, as we say. They've admitted the crime, which is more than we can say about the Turks and some other people. And we do have judicial mechanisms that enable us to get our fingernails into them, like the European Court of Human Rights. So let's keep going, do it in a smart and a strategic way, and it will help to advance the idea that even big countries, even permanent members of the Security Council, I won't name any of the other four, could eventually be held accountable. And then we'll all be much more committed to the effectiveness of international justice because we realize that it works for everybody and will be a better world for it.
And the last word goes to David Crane.
I'll just answer the question related to what was the law extant at the time. It was the laws and customs and courtesies of war with the Hague Rules of 1907. I could give you a history lecture. So there was a body of law which governed conduct on the battlefield. As far as I agree, we eventually will get to the point where large countries will be held accountable. It is a challenge. If a double standard appears to be developing, modern international criminal law and all of the great advances that we have started over the past 15 years will begin to crumble because, again, it's smaller countries versus bigger countries. You know, who's going to take on China for their human rights violations in the Olympics, where they moved whole peoples to the east of their country, never to be seen again? They cleaned out Beijing. And who's going to take on a larger country related to their particular human rights problems? Who's going to take on the United States for their human rights problems or their aggressive war in Iraq? And then, of course, at the bottom line is that modern international criminal law, the bright red thread of how states act related to atrocity is politics.
Right. Well, first, please join me in thanking this panel. Great wrap-up panel. if you really want to wrestle with these issues, I invite you back tomorrow morning. We're going to be across the hall in a...
Tomorrow morning.
Yep. We're going to be across the hall in a circle, and we're going to be debating these for 2.5 hours and creating an experts report. I want, before you run off, to thank some people that made this possible. Alice Simon, who's there, Jared, who's run off, and Nancy Pratt. Our AV team, which does such a great job of beaming this around the world.
That probably calmed the drug wars. Maybe
The co-sponsors, and then everybody who was a panelist. Can you just all stand up collectively?
Well, you know, in French, when they talk about
all the panelists.
blasted on drugs, they say frozen.
All right, with that, I declare this day of the conference over. Thank you very much.